नमस्ते फ्रेंड, आप सभी का एक बार फिर से वेलकम। फ्रेंड्स, हमारे जो पेंशन एक्टिविस्ट श्री CN वेणुगोपालन सर का एक आर्टिकल जगलरी ऑफ जस्टिस बाय द इंडियन बैंक एसोसिएशन LIC पेंशनर क्रॉनिकल में पब्लिश हुआ, उसका पार्ट मैं आपको शेयर कर रहा हूँ। श्री CN गोपालन सर ने इसको लिखा है। इंडियन बैंक एसोसिएशन caused banks in India to deny 100% dearness relief neutralization on full basic pension to the pre-November 2002 bank pensioner and to pay it to the post-November 2002 pensioners during the period from 1st May 2005. A palpable discrimination among similarly placed pensioners. When pensioners challenged the issue and got favorable orders from Kolkata High Court at single and division bench, IBA, Government and United Bank of India fiercely argued in civil appeal number 525 to 5255 of 2018, United Bank of India versus United Bank of India Retirees Welfare Association and others, secured an order on 16 May 2018 to the effect that pre-November 2002 retirees are not entitled to 100% dearness neutralization. The appellants, United Bank of India, IBA and government could engage prominent counsel to get a decision in their favor in 3 months through unfair means. Paragraph 4 of the ruling dated 16 May 2018 shows that the appellants produced the pension regulation of the Mumbai-based Union Bank of India instead of producing the pension regulation of the Kolkata-based United Bank of India. Seemingly, they did so because the pension regulation of the latter was not updated till the time of producing in the court. The Honorable Supreme Court placed reliance on a joint note dated 2nd June 2005 of the IBA when another co-equal bench of the court had 3 months back on 13 February 2018 laid down in civil appeal 5255 of the 2012 VJ Bank of Baroda and others versus G. Palani and others that the joint note has no statutory basis and cannot supplant any of the provisions of the pension regulations. The judgment dated 16 May 2018 in civil appeal 525 to 5255 of 2018 was per incurium of the judgment dated 13 February 2018 in civil appeal number 5255 of 2018. The arithmetic applied by the Honorable Court too went wrong unfortunately and justice got fractured. About 2 lakh of bank pensioners who retired prior to 1st November 2002 lost a portion of their dearness relief from 221 months from 1st May 2005 to 30 September 2023. Queerly, 5 years after obtaining the erroneous judgment by arguing furiously in the courtroom that the pre-November 2002 retirees are not entitled to 100% DR neutralization, the IBA recommended to the government that the benefit shall be paid to them from the date it is sanctioned by the government and the Department of Financial Services. Ministry of Finance, Government of India sanctioned it from 1st October 23 via the letter number 5th October 23 addressed to the IBA. In the process, the Government of India, the IBA and the banks have disapproved all the reasoning of the Supreme Court that led to the judgment dated 16 May 2018 against the pre-November 2000 pensioners, because if the reasoning of the Honorable Supreme Court was right, the Government of India, the IBA and the banks would not have and could not have done what they have done now. Clearly, the Government of India, the IBA and the bank have played a cruel joke on the pre-November 2002 pensioner using the instrumentality of the judiciary. The DFS was telling in its sanction dated 15 October 23 that no arrears shall be payable for the period falling before the effective date, exercising a discretion which is provided by the Constitution Bench of the Honorable Supreme Court in its ruling dated 17 December 1982 in the D.S. Nakara versus Union of India, where it was held that payment of pension is not subject to the discretion of the government and that it is governed by the rules. IBA and government joined hands together and allowed the banks to swallow in a gulp the dearness relief payable to the helpless pre-November 2002 bank pensioners numbering nearly 2 lakhs, which was in the range of rupees 10 to 15 lakhs exclusive of the interest. Narrated above is a case wherein the Honorable Supreme Court could suo motu proceed against the appellant in civil appeal 5252 to 5255 by invoking the maximum actus curiae nimium gravivate act. The court shall not prejudice no one, the court shall neutralize the loss caused to them. In the civil appeal number 5561 of 2016, MC Singla and others versus Union of India, filed by the pensioners who are David's fighting with the Goliath for the getting their pension updated. The IBA and the government are obstructing the administration of justice by trickling the Honorable Court. Initially, as directed by the Honorable Court, the IBA appointed a committee to look into the matter of updating pension, but did not submit its report and sought extension of time for its submission on a plea that the chairman is demitting his office. Subsequently, they filed a false affidavit on 24th August 22, stating that the pension regulation of banks do not have provisions for updating pension, notwithstanding that Regulation 35(1), as amended in 2003, lays down that the basic pension and the additional pension, wherever applicable, shall be updated as per the formula given in Appendix 1. The regulation initially notified on 29 September 95 stood as in respect of the employees who retired between the 1st day of January 86 but before the 31st day of October 87, basic pension and additional pension will be updated as per the formula given in the Appendix 1. The time frame of the retirement of the employee was removed in 2003 and emphasis to the updating was given by laying down that pension shall be updated wherever applicable and also by replacing the phrase will be updated with shall be updated. If IBA is of the view the pension regulation do not have for updating pension, it has to clarify why they mentioned about the updating of pension in the initial proviso and why they amended the proviso in 2003, giving emphasis to the updating. The precursor of the pension regulation was the settlement dated 29th October 93, signed by IBA with AIBA pursuant to the Industrial Dispute Act 1947. Clause 6 of the settlement agrees that dearness relief to the pensioner will be granted at such rates as may be determined from time to time in line with the dearness allowance formula in operation in Reserve Bank of India. And Clause 12 agrees and provision will be made by a scheme to be negotiated and settled between the parties to this settlement by 31st December 93 for applicability, qualifying service, amounts of pension, payment of pension, commutation of pension, family pension, updating and other general conditions, etc. on the lines as are in force in Reserve Bank of India. The minutes dated 26 March 94 of the Small Committee on Pension Constitution constituted by IBA recorded in its the preamble to formulate the pension regulations on similar lines as Reserve Bank of India pension regulations as applicable Reserve Bank of India employees and central civil services pension rules applicable to the central government employees by making suitable modification in relation to its applicability to the banking industry. In class 4.2 of the minutes, it was recorded that the formula for updating pension should be on the line of the same given in the Reserve Bank pension scheme. Any change therein should be introduced only after the mutual agreement. Leave alone the legal obligations, Mrs. Nirmala Sitharaman, Minister for Finance, had advised the IBA in her keynote address at the 73rd Annual General Meeting on 20th November 2020 that bank pensioners shall not be left to themselves post-retirement and they shall be given OROP, one rank, one pension, in view of the laudable service they had rendered for the banks while in service, as was granted by her to the defense pensioners. But neither the IBA nor the Department of Financial Services took care of the words of the minister, and her reassuring words brought double disappointment to the bank pensioners. The non-revision of the pension in the banks is also is breach of the Section 10(7) of the Banking Companies Act 1970. It permits bank to declare a dividend and to the retain surplus profits as accumulated reserves in the books only after making due provisions for superannuation funds. But banks had been declaring dividends ranging from 10 to 270% and mounting the reserve manifold without paying due pension as mandated by the pension regulation in breach of the Act. It is also pertinent that the Civil Appeal 1123 of 2015, the Honorable Court held that the pension is the deemed property of the employee even in a scenario where pension is payable out of the tax money with the cost of the exchequer. In the case of bank, the pension is payable out of the pension funds created out of the CPF surrendered by the employees and the CPF refunded by the employees who retired on or after 1st January 86, who were taken into the pension scheme, and pension is payable out of the real property of the employees and not out of the revenue account of the banks or out of the exchequer. The pension fund of all banks, including State Bank of India, on 31st March 24 issued rupees 4,26,7,644 crores with annual growth of about rupees 49,000 crore during 23-24, and all banks can pay more than double the present pension out of the annual growth itself without touching the corpus of the fund. As such, the non-updating of pension in the banks is sure to attract the wrath of the court through strictures passed against the IBA. IBA has, through its joint note dated 27th April 2010, excluded employees who joined banks after 31st March 2010 from the pension scheme by placing them in the new pension scheme to kill the pension scheme. This ended up in the subscriptions the banks are to make to the pension fund in respect of such employees to the pension fund to go to the new pension scheme of the government. It will further result in the pension fund which comprise the CPF and deferred wages of the employees and the pensioner becoming the property of equity of the banks when employees who joined service till 31st March 2010 and their families get extinct. This was a clever way of making the own fund of the banks their own funds. The present pensioners are mostly of the age group of 70 to 90 and the pension liability of the banks will be nil in 10 to 20 years. The name Indian Bank Association is misleading and it conveys a picture that it is the government or nation or agency. The IBA does not figure anywhere in the pension regulations, yet it acts as an extra constitutional authority interfering in the administration of the pension regulations every now and then, though it is only a voluntary association with absolutely no powers. This voluntary association is operating with the money it collects from the members' banks, running in several crores with the blessing of the Department of Financial Services. It is in the most corrupt way of the banks have no provision for making any payment to the IBA. Public money is looted by the IBA, whose members are public sector banks, private banks, foreign banks and new generation banks, regional rural banks, cooperative banks and even NBFC. It is strange that a voluntary association like IBA, which does not have a regulations under any Indian institute, is playing around with the pension regulations, which is the dispensation of the Indian legislature. It is the turn of all retiree organization, pension activists and the individual bank pensioner to stand up against the IBA and to redeem their rightful pension, which is out of their own deferred wages held in the pension funds. Jai Hind. Yours faithfully, Sri C.N. Venugopalan. Thank you, friends. Namaste.